Dear learners, in our previous class, we discussed about the regional arrangement of human rights, and we discussed about the how these regional arrangements are playing their role in promoting human rights globally, and what is their significance. And we had already started our discussion on the European Convention on Human Rights, and we found that how this convention uh, was inspired by UDHR, and also we discussed that how the circumstances that developed, or the situation that developed after the Second World War, that motivated people to develop this kind of organization in Europe. Uh, this was the spirit of never again, that was there all over Europe. That was instrumental in giving a concrete shape to this kind of organization. We discuss about why this regional mechanism, that is European Convention on Human Rights, is appreciated for being one of the best regional mechanism to promote and protect human rights. Now we are going to discuss its various provisions and then implementation machinery. When we see that the European Commission on Human Rights initially had three implementation machinery. When it was established in 1953 and came into force it was established in 1950 and entered into force in 1953. So initially it had three implementation machinery. Number one, the European Commission of Human Rights, which was set up in 1954. This is again a very important instrument of implementing human rights under the convention. Then the European Court of Human Rights, set up in 1958. You see that how the organization is progressing, how the convention is trying to make it more, more effective. So first of all, the European Commission of Human Rights is being created. After that, you will find that the European Court of Human Rights, and then the Committee of Ministers of the Council of Europe, where all the states are represented, all the member states. Today, the strength is around 46. So, the Committee of Ministers of the Council of Europe. So, these three important bodies were given the responsibility of implementing and enforcing the rights that are there in the convention. The Protocol 11 of the ECHR, this is very important. The Protocol 11 of the ECHR restructured the implementation machinery and merged the Commission and the Court in 1998. You see what happened that earlier these three important bodies were there, but now what happened that the Commission, the European Court of Human Rights and the European Commission of Human Rights, they were merged. Rather, you can say that the European Commission of Human Rights was merged into the European Court of Human Rights. And since then, since 1998, it is working, this European Court of Human Rights. It has become a permanent body to implement and give interpretation to the rights that are mentioned in the European Convention on Human Rights. The European Court of Human Rights oversees the implementation of the convention in the 46 Council of Europe member states. You see its jurisdiction. So all the 46 members who are the member of the Council of Europe, they have agreed upon it, and the jurisdiction of the court, if you see the European Court of Human Rights, it is all the 46 countries, they are the member of the Council of Europe, and that is why the jurisdiction of the court includes all these 46 countries. The European Court of Human Rights is situated in Strasbourg, France, which acts as the ultimate arbiter in adjudicating cases brought forth by individuals and states alleging violations of the convention. Interestingly, you see the implementation machinery, that is working. The individuals living in these 46 members, 46 member countries, they can directly approach the court, European Court of Human Rights, against the violation of human rights if that is taking place by their own government or by any entity. So they can directly approach the European Court of Human Rights, that we can call individual petition system, and it is not optional. All the countries have to agree upon it. And then Interstate complaint mechanism is also there. So the states can also, bring the cases to the European Court of Human Rights. So not only the individuals, but the states can also bring the cases, and ultimately the interstate complaints are also entertained by the European Court of Human Rights. The court's decisions carry significant weight, influencing legal developments and human rights jurisprudence within Europe and serving as a model for other regional and international systems. Yes, you see, the European Court of Human Rights, it has given many judgments. The judgments delivered by European Court of Human Rights, so far as the protection or the issues of violation of human rights are concerned, they are cited all over the world. So it is also setting a standard of setting a standard of enforcement of human rights or promotion and protection of human rights by delivering judgments. In those judgments, you will find that the rights of different kinds, they are recognized, and these rights, they are of course leading to expanding the catalog of rights all over the world. So the different countries, different regional mechanism, even the international organizations like the United Nations, sometimes they also get inspiration from the judgment, from the interpretation, and from the approach that the court adopts towards the promotion of human rights. Since its adoption in 1950, the convention has been amended several times and supplemented with many rights in addition to those outlined in the original text, making it a living instrument. So, why it has become a living instrument of human rights? Because you'll find that it has been amended several times. So, that consensus can be developed only when all the countries, they are coming from same kind of values. So that is why they are able to develop this kind of mechanism. So the different protocols that have been adopted, additional protocols, basically they are trying to make this convention, or the what we call the Treaty of Human Rights, a very effective one and also a living treaty. Features of the European Convention on Human Rights. So, first of all, what are the dominant features of the European Convention of on Human Rights? It is comprehensive protection that is there. So, this European Convention on Human Rights enshrines a wide range of civil, political, and other rights applicable to everyone within the jurisdiction of member states. So, you see the catalog of rights that is there. It is including almost all the civil and political rights that are there in the ICCPR. It is including all the important rights that are, there in the UDHR. So, you'll find all the important rights that are there in the important international treaties, they have been included in it. And other sets of human rights, not only civil and political rights, but you will find other rights have been also recognized and they have been promoted. Another important feature of the ECHR is individual petition right. So individuals can petition the European Court of Human Rights if they believe their rights under the convention have been violated by their governments. Again, this is significant, quite revolutionary, that the individual can, level charge against their own government in the European Court of Human Rights. Binding judgments. The court judgments are legally binding on member states, requiring them to remedy violations and provide appropriate compensation. So it is restoration of the rights that is done through the judgments. So that is why the judgments that are delivered by the European Court of Human Rights, they are binding on all the member states. And in many cases, you will find it is asking the governments or the member states to compensate through different mechanism if the violation of rights have taken place. Independent court, the court, that is the European Court of Human Rights, is independent, impartial, and very effective. And it is independent of national governments and political influence, ensuring impartial judgments. You see that if you see the composition of the court, that also you have to take into account. The composition is such where you'll find all the member states will be submitting three names and one will be selected for the judges. and these judges, they rise above their parochial national interest, and they try to promote the interest of all living in Europe. So that is why the this is an approach that has been adopted by the court, and because of which you will find that on the account of human rights, Europe or the Council of Europe is doing better than other regions of the world. Regular monitoring. The Council of Europe conducts regular monitoring of member states' compliance with the convention's provisions. You will find it not only an eye wash. You will find most of the time what happens that the in the ICCPR or ICHR, the committees, when they are going to they are going to see the periodic reports submitted by the countries. Most of the reports submitted by the national governments are basically just eyewash. They try to hide many things. Violations they will try to highlight, and whatever steps they have taken for promoting human rights, like institutional mechanism, etc., or even cosmetic efforts have been done, they will try to highlight that. And you will find that these committees are not so powerful that they can punish the states. So the observation will be there, some kind of observation they can give some kind of recommendation they can give. But here you will find that the Council of Europe is very sincere in implementing and enforcing rights that are there in the convention. So the constant monitoring by the Council of Europe of the states, that leads to better protection of human rights in Europe. Dynamic interpretation. The ECHR can interpret the convention's articles in light of changing circumstances and evolving social norms, ensuring their continued relevance. This is also the adaptability that has been shown. I think the best part of the liberalism is that it is quite flexible, and it accepts the challenges, rather addresses the challenges. So that is why you'll find that the European countries, they are mostly Western liberal nations. So that is why they have given dynamic interpretation to the rights, and they have also through protocols they have added many new rights in the convention. So that is why, because of this, it becomes a quite dynamic organization. It becomes quite dynamic arrangement for the protection of human rights. Then we have protocol system. Additional protocols have been adopted to expand the scope of protection beyond the original convention, addressing issues like torture, the death penalty, and human trafficking. These issues, they came up later. They were not addressed by the original convention, but you'll find through protocols, that the mechanism protocol that is there, the Council of Europe has addressed these problems, and that is why the catalog of right has been widened. Collective complaints. Another important feature that we should remember: NGOs and other groups can submit complaints on behalf of victims of human rights violations. In many cases, what happens is that the victims are so tormented, or they are so weak that they cannot approach the court. So that's why the public spirited individuals, activists, or the organizations that are working in the field of human rights, they can also approach the organization for the protection of human rights or against the violation of human rights. So that is when the NGOs and groups or the activists, they can also approach, that makes the organization more responsible, more accountable. And because of that, you see what happens, that the victims of the violation of human rights, they get justice through this European Court of Human Rights. Friendly settlements. States and applicants can reach out of court agreements before the court makes a judgment. This is also important. You see that the peaceful settlement of disputes, as we see, that is always emphasized at the international level. Here also you'll find, if the individuals have grievances against their own state, or if the states have grievances against other states, so out of court settlement can also be there through negotiation, dialogue, discussion, deliberations. This is also important. Advisory opinions. The European Court of Human Rights can issue advisory opinions on legal questions submitted by member states. So you'll find that this European Court of Human Rights becomes the final arbiter in this sense. It is interpreter and arbiter. It will give interpretation, advisory opinions on the issues relating to human rights and similar other issues. Impacts and significance. So, what is the impact of these kind of efforts, and what is the role of the European Court of Human Rights, which is being appreciated all over? Landmark rulings. First of all, the ECHR has the European Court of Human Rights has issued numerous landmark rulings that have significantly improved the lives of individuals across Europe, setting precedents on issues like same-sex marriages, religious freedom, and police misconduct. The Council of Europe maintains a very high standard of police conduct, and this is the reason that for example, when the police is compared, the policing in Europe is not atrocious. It is not full of cruelty. Most of the time, you will find excessive use of violence or excessive use of force. You will not find. It is seldom reported from Europe. Whereas in the global south or in the developing world, you will find that the excessive use of police is often accused of excessive use of force, power, and it is accused of fake encounters, torture, all. Here you will find that what has happened because of the landmark rulings of the European Court of Human Rights. The police misconduct has been taken up very seriously, and that is why the police is very conscious when dealing with the issues of human rights or dealing with the citizens. So the police community relations in Europe or under the European, this Council of Europe, that is quite cordial in comparison to the police community relations that we see in many developing countries. Again, you will find that, for example, we were talking about the same-sex marriages, religious freedom, etc. All these things, they have been taken up through the European Court of Human Rights, and that is why now the European Court of Human Rights, in a way, is also playing its role in what we call expanding the horizon of rights in the convention. Model for other regions. The ECHR has served as a model for the development of other regional human rights instruments worldwide, influencing international human rights law and jurisprudence. So, the judgment given by the European Court of Human Rights, the various developments that have taken place in the ECHR, they have become a source of inspiration for many countries and other regional instruments of human rights. Promotes dialogue and understanding. The convention fosters dialogue and cooperation among member states on human rights issues, contributing to a more unified and rights respecting Europe. So, through dialogue, discussion, deliberation, churning, seminars, conferences, sensitization, all these things, they are that it has been promoting, and because of that, you will find that human rights get greater acceptability and respectability in Europe. Now, after discussing, these things like features, etc., we are going to discuss the provisions of the convention. First of all, you'll find that the convention has a preamble, and it starts, the government signatory hereto being members of the Council of Europe. As we discussed that it was the Council of Europe that adopted this convention. So, considering the Universal Declaration of Human Rights, you see, in our previous lectures, we have been discussing that the UDHR is the most cited, human rights document in the world. Here you'll find in the preamble what is being cited, UDHR. Considering the Universal Declaration of Human Rights proclaimed by the General Assembly of the United Nations on 10 December 1948. You see, the Human Rights Day that we observe every year, 10 December. So it is being cited here. Considering that this declaration aims at securing the universal and effective recognition and observance of rights therein declared, Considering that the aim of the Council of Europe is the achievement of greater unity between its members, and that one of the methods by which this that aim is to be pursued is the maintenance and further realization of human rights and fundamental freedoms. You find what is being emphasized: human rights and fundamental freedoms, core values of liberalism, reaffirming their profound belief in those fundamental freedoms which are the foundation of justice and peace in the world, and are best maintained, on the one hand, by an effective political democracy. You see, the Western liberal values or the liberal notion of human rights are being emphasized. So, it is being said that uh, so reaffirming their profound belief in those fundamental freedoms which are the foundation of justice and peace in the world, and are best maintained, on the one hand, by an effective political democracy, on the other, by a common understanding and observance of human rights upon which they depend. So, you'll find the liberal paradigm of human rights is being emphasized, being resolved as the governments of European countries which are like minded and have a common heritage of political traditions. You see, it is liberalism, capitalism, that binds them together. So, being resolved as the governments of European countries which are like minded. Like minded means the political values, especially, they are same, and a common heritage of political traditions, ideals, freedoms, and the rule of law, to take the first step for the collective enforcement of certain of the rights stated in the Universal Declaration, affirming that the high contracting parties, means member states, in accordance with the principle of subsidiarity, have the primary responsibility to secure the rights and freedom defined in this convention and the protocols thereto, and that in doing so they enjoy a margin of appreciation subject to the supervisory jurisdiction of the European Court of Human Rights established by this convention. You see, the jurisdiction of the European Court of Human Rights is also being recognized here in the preamble itself. So you see that the preamble is already emphasizing that there is a commonality of political belief and traditions in the member states of Council of Europe. You will find for giving membership itself, you see democracy, especially the liberal model of democracy, that is must. As amended by Protocol 11, the convention, significant provisions we are going to discuss now. As amended by Protocol 11, the convention consists of three parts. The main rights and freedoms are contained in section 1. So the first part you will find is dealing with the main rights and freedoms, which consist of Article 2 to 18. Then section 2nd or the section 2, you will find part 2. So in the section 2 or part 2, you will find that Articles 19 to 51 set up the court and its rules of operation. It is dealing with the European Court of Human Rights, its rules of operation, its composition, its jurisdiction, etc. And section 3rd contains various concluding provisions, means about the convention or about the treaty. Now we are going to discuss the catalogue of rights under this convention. Article 1, for example, you will find obligation to respect human rights. The high contracting parties shall secure to everyone within their jurisdiction the rights and freedom defined in section 1 of this convention. Article 2, right to life. Everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court, following his conviction of a crime for which this penalty is provided by law. So you see, Article 2 is talking about right to life, but it is also here, it has become redundant because you see, in Europe it has been already abolished, death penalty has been abolished. So the right to life Everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save means exceptionally, in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. Means death penalty. Now it is not applicable. Article 3. So, since the death penalty has been abolished in the Council of Europe, so death penalty cannot be given. Article 3. Prohibition of torture. No one shall be subjected to torture or to inhuman or degrading treatment or punishment. You will find it in consonance with the UN Convention Against Torture. You will find that European Union has also completely banned torture of any kind against any individual. This provision is why important, because in most of the developing countries, in the countries of Asia, Africa, Latin America, you will find that torture in the custody of the police or torture in the custody of the security agency is very common. So that is why the national mechanism in our own country, for example, National Human Rights Commission, you will find the Supreme Court of India is also issuing guidelines against torture in our own country. So that is why you see this is a serious problem. Torture in the custody of the police or in the lockups where the third degree is applied and many people die in the custody. So that is why torture or inhuman or degrading treatment or punishment cannot be given. It has been already accepted. Article 4. Prohibition of slavery and forced labor. So now, slavery has become, of course, something, phenomenon that was there in the past only. Now it cannot be justified anywhere in the world. Slavery is completely, it has been criminalized. No one shall be held in slavery or servitude. One, no one shall be required to perform forced or compulsory labor. Again, this is very important. No one shall be required to perform forced or compulsory labor. So even compulsory labor is not, something that is acceptable under this convention. Article 5. Right to liberty and security. Everyone has the right to liberty and security of person. No one shall be deprived of his liberty, save in the following cases, and in accordance with a procedure prescribed by law. So, there are certain circumstances under which, the personal liberty of individual can be curtailed. Otherwise, in normal circumstances, they cannot be taken away. So, and what are these? What are the exceptions? The lawful detention of a person after conviction by a competent court. So, when there is a lawful detention of a person after conviction by a competent court, so then personal liberty, of course, when the person is being detained, his personal liberty or her personal liberty is all curtailed. The lawful arrest or detention of a person for non-compliance with the lawful order of a court or in order to secure the fulfillment of any obligation prescribed by law. This is second exception. The lawful arrest or detention of a person effected for the purpose of bringing him before the competent legal authority on reasonable suspicion of having committed an offense or when it is reasonably considered necessary to prevent his committing an offense or fleeing after having done so. So you see, preventive detention can be there. So a person can be arrested if or detained in the custody if there is a suspicion or there is some kind of suspicion in the mind of the enforcement agencies that if he is free, he can commit some kind of crime. So ultimately, then under that kind of circumstances, also a person can be detained. The detention of a minor by lawful order for the purpose of educational supervision or his lawful detention for the purpose of bringing him before the competent legal authority. You see, it is beautifully what is educational supervision. It means, so if there is a minor and we, for example, in our country are living under what is called child labor. It is said that 1/4 of the child labor force is there in our country, India. And you see what kind of child care is being taken care of here. So that they are saying that the detention of a minor by lawful order for the purpose of educational supervision. So, education is so important for the minor over there. Or his lawful detention for the purpose of bringing him before the competent legal authority. Another important exception, the lawful detention of persons for the prevention of the spreading of infectious diseases or persons of unsound mind, alcoholics or drug addicts or vagrants. They can be, of course, detained, of course, but the order must be there from the court. That should be lawful. The lawful arrest or detention of a person to prevent his effecting an unauthorized entry into the country or of a person against whom action is being taken with a view to deportation or extradition. So, this is again, these days you will find in the European countries, migrants are facing many challenges. And when the migrants, for example, there are many people who are trying to enter into Europe without any visa through the unlawful means. So if these people are detained, that is allowed, of course. Uh, and again, there are some people who have committed some kind of crime and after that they have fled to Europe. So if they are living over there, they can be detained for extradition because under that, if a person has committed some kind of crime in some other country and has fled somewhere, then under the international law, extradition is permissible. Rather, extradition is sought. So for the purpose of extradition, again, the person can be detained. With this, we are concluding our lecture today. In the next lecture, we will continue with the provisions of the European Convention on Human Rights, and you will find that the horizon of rights or the catalog of rights that are there in this convention, they are quite, they have been broadened with many protocols that have been added from time to time, and you'll also find that it is a very advanced kind of mechanism of human rights which is giving due recognition to legitimate claims of individuals to political freedom, to political rights, civil rights, and other rights. So that we will continue to discuss. Thank you. We are meeting in the next lecture.